morning and welcome to another episode of Oxford University Undergraduate Law Journal podcast. I'm your host Isaac, and today we are joined by Professor Anselmo Reyes SC. Professor Reyes started his career as a barrister at the Hong Kong Bar in 1989. He took cert in 2001 and was later appointed as judge of the Hong Kong High Court, where he oversaw the construction and arbitration list and later on the commercial and admiralty list. He's now a renowned international arbitrator, having ranked in most in-demand arbitrators by chambers and partners. He is also an international judge of the Singapore International Commercial Court. He has written many books on international arbitration and dispute resolution, including The Practice of International Commercial Arbitration, a handbook for Hong Kong arbitrators. Good morning, Professor Reyes, and welcome to the podcast.
Good morning. Thank you for having me.
Okay, so just to start off, for our listeners who do not know much about international arbitration, could you give a brief summary of its origins as well as its key doctrines? For example, the competence doctrine.
I think I can best answer that question by putting the problem faced by commercial parties in context. So let us assume you have a commercial agreement, a commercial contract, and that commercial contract has international elements. So the parties, for instance, may be in different countries. At some point, a dispute may arise out of the matters in the commercial contract, and the parties have to try to resolve their dispute in some way. They may try negotiation or mediation, but ultimately they may have to go to court or arbitration, some form of dispute resolution if they can't come to any settlement agreement. Let's assume that they come to the court or they come to arbitration. At the end of the day, you reach the point where you get a judgment if you go to court, or you get an award if you go to arbitration. And because of the international elements, how are you going to enforce that judgment somewhere else in another country? How are you going to enforce that arbitral award in another country? Now, the general thinking is that it's difficult to enforce a judgment, a commercial judgment for a liquidated amount of money, let us say, across borders, unless there's some sort of treaty between the two countries involved. Then there may be difficulties in enforcement of that judgment. Arbitration, however, has something special. There's a multilateral treaty or convention known as the 1958 New York Convention, to which most countries, over 170 countries, are party. Now, under that convention, you can enforce an arbitral award, a commercial arbitral award, across borders in all the other parties to the 1958 New York Convention. So arbitration in commercial matters is perceived to be more effective from the point of view of enforcement than a judgment and then a commercial judgment. And that's what is making arbitration, international commercial arbitration, especially attractive. So that's, I think, why international commercial arbitration has become very popular. Now, there are a lot of principles of international commercial arbitration law. You've referred to competence. Let me just focus on that. What is competence about? Well, a problem that often arises when you have an international commercial dispute is whether the arbitration agreement is effective. Parties might say, at the most basic level, there is no arbitration agreement between us. What you purport to be an arbitration agreement between us is actually not something that I agreed to. I didn't sign, or it's been forged, or some such complaint. It doesn't cover this dispute. So who's going to determine whether the arbitral tribunal, the arbitrators appointed pursuant to the terms of the arbitration agreement, have been validly appointed under an arbitration agreement that is binding between the parties? Will it be the court, or will it be the arbitral tribunal? Now, the doctrine of competence posits that the arbitral tribunal has competence, authority, to determine whether it is competent to hear a case, to adjudicate over a dispute between commercial parties. So they can, the arbitral tribunal, the members of the arbitral tribunal, can decide whether the arbitral tribunal has the authority, the jurisdiction, to decide the substantive dispute between the parties. That is the doctrine of competence. Now, competence implies two other matters. One is, in order for this doctrine to be effective, you have another doctrine, a supporting doctrine, which is called the separability of the arbitration agreement. For the purposes of determining whether there is a valid, enforceable arbitration agreement between the parties, you treat the arbitration clause in a contract, in a commercial contract, as separable. Therefore, you can have a long main contract, main commercial contract, with all sorts of clauses and provisions, and somewhere embedded in that contract is an arbitration clause. For the purposes of determining the jurisdiction, the authority of the arbitral tribunal to decide a case, you treat that arbitration clause embedded somewhere in that long commercial contract as separate. So for the purposes of determining their jurisdiction, they can determine whether or not that arbitration clause is valid. You treat it as separate. You see, very often parties will assert that the whole contract, the whole commercial contract, has been vitiated for some reason. Illegality, misrepresentation, mistake, duress, undue influence, you name it. Nonetheless, you need an arbitral tribunal to determine whether that allegation, that the main contract has been vitiated by some factor, you need an arbitral tribunal to determine whether that is or is not authentic. Now, they will, one party may say, well, no, the arbitration agreement is also vitiated. And the response to that would be, no, on the doctrine of competence, the arbitral tribunal may determine its authority. And further, corollary to that is you treat the arbitration agreement as separate. So the rest of the contract may be vitiated by some factor, mistake, misrepresentation, etc. But the arbitral tribunal still has the competence to determine the validity of the arbitration agreement due to the separate nature of the arbitration agreement. The other matter that perhaps I should raise as being posited or implied by the competence doctrine is the word of the arbitral tribunal on its competence. Their determination, the tribunal's determination of its own competence, cannot be final. The court will typically have the final word on whether the arbitral tribunal's determination is or is not correct. Their determination on jurisdiction. Usually, if a party is unhappy with an arbitral tribunal's determination of its jurisdiction, that unhappy party will have 30 days under the ancestral model law, for instance, to apply to the court, to appeal to the court against the arbitral tribunal's determination. So the arbitral tribunal has the competence to determine its own competence, but that's not final. You can go to court for an appeal against the arbitral tribunal's determination if you're unhappy with it.
Thank you. Just picking up on what you said earlier, I think what I noticed is a little bit of a tension between arbitration tribunals and the court in the sense of how much support is arbitration tribunals getting from actual statutory law or even from the courts of the country. And just to bounce off on that, maybe to bring it first to the country that we're in the UK, what are your thoughts on changes to the UK arbitration law in the Arbitration Act 2025, in particular the changes to the governing law of the arbitration agreement and arbitrators' duty of disclosure?
Let's start with the first one, the governing law of the arbitration agreement. And let's go with some background once again, to put it in context. I referred earlier to the New York Convention, the 1958 New York Convention. If you look at the 1958 New York Convention, in particular, Article 5.1a of the New York Convention, typically, under the New York Convention, an award may be set aside by the competent authority, the court of a particular country, if the award is made outside of the bounds, outside of the jurisdiction given by the arbitration agreement. And Article 5.1a of the New York Convention puts forward certain bases on which you determine what is the law governing the arbitration agreement. And if you look at the New York Convention, what it says is the first basis is, have the parties actually expressly stated a governing law of the arbitration agreement? If the parties have stated a governing law of the arbitration agreement, that is the governing law. That's an express statement. Otherwise, if there is no express statement, then the governing law will be the law of the seat of arbitration. I'll explain that in a moment. The law of the seat of arbitration will govern the arbitration agreement. What is the seat of arbitration? Let's look at an arbitration. Let's look at a commercial contract. Several laws may govern different parts of that commercial contract. Thus, the, shall we say, substantive part of the commercial contract, that part of the commercial contract other than the arbitration agreement, may have its governing law, may have its proper law, for instance. Parties will have expressed that proper law, or it may be implied, whatever. The arbitration agreement may have a different governing law. And the question we're now concerned is how to determine the governing law of the arbitration agreement. And finally, the arbitration procedure has its own law, the procedure law governing the arbitration. And that will typically be the law of the seat of arbitration, the law of the place where the parties have stipulated, hopefully, in their contract, the arbitration procedure law of that state place is to apply. So they identify a place as the seat of arbitration, and the law of that seat will govern the procedural law of the arbitration. Now, the problem is parties don't often specify a seat expressly. So you may have to determine the seat, but usually it's not too much of a problem. The arbitration agreement may say something like, the arbitration is to take place in Beijing. Well, that's a pointer to the arbitration seat being the People's Republic of China, for instance. Or the arbitration may be governed by, the parties specify that the arbitration is to be governed by the rules of the Singapore International Arbitration Center, the SIAC, currently in force. Well, that's a pointer to the parties intending the arbitration to have a Singapore seat. In other words, the arbitration proceeding to be governed by the law, the arbitration law of Singapore. So they're usually pointers to what the parties intended or must have intended the seat of arbitration to be. So you discern what the seat of the arbitration is, and in the absence of an express provision stating what the governing law of the arbitration agreement is, then you deem the law of the seat to be what the parties intended to be the law of the arbitration agreement. Now, let's look at the position in England before the Arbitration Act amendments, the recent Arbitration Act amendments that came into force this year. Under a UK Supreme Court case called and Chubb, that was a 3-2 decision of the UK Supreme Court. But if you look at what the law lords held, it's not too different. They came to different conclusions on the facts, but the principles seem to me relatively the same, whether you take the majority or the minority view. And that was that in determining what is the governing law of the arbitration agreement, you proceed this way. You first see if the parties expressly stipulated a law, a governing law. Then, if there's no express stipulation, you see what is the implied law. You look at all the facts and circumstances to see what is the implied law. And if you can't imply the law, or if that's not possible, then and only then do you look at the law of the seat of arbitration. Now, that runs contrary to the New York Convention, or what the New York Convention appears to say. There are people who argue that, no, the New York Convention says exactly what was said in Enka and Chubb. But that seems to be contrary to a lot of judgments around the world, as to what Article 5.1a of the New York Convention is saying in regard to determining the governing law of an arbitration agreement. So this caused confusion. Enke and Chubb caused some confusion because before you look at apply the law of the seat, you have to try to see what the implied law of the arbitration agreement is. And as you can see from Enke and Chubb itself, different people may come to different conclusions, reading the facts, looking at the facts and circumstances as what is implied or not implied. And therefore, to maintain London's preeminence as a seat of arbitration, as a seat where people go to resolve their international commercial disputes, the legislature decided to amend this and to stipulate that no, henceforth it will be exactly as everyone thought the New York Convention was saying. In other words, you look to see whether there's an express choice of law. If there is no express choice of law for the arbitration agreement, then you apply the law of the seat. That will be the law that will be applicable to the arbitration agreement. And as I said, usually it will be a relatively straightforward matter to determine the seat of arbitration. Now, some English lawyers, some English professors will say that every arbitration must have a seat. They are not too keen on the idea of delocalized arbitration. We don't need to go into that now, but typically, especially within the common law, you can basically go on the principle that every arbitration has some sort of seat, and that seat will, in the absence of an express provision, govern the arbitration agreement. Now, let's go to the other matter that the arbitration law, the new arbitration law enacts. There are many other matters that have been enacted, but let's focus on what you highlighted, disclosure. There is another case called Halliburton in which the arbitrator forgot to make a certain disclosure. The arbitrator forgot to disclose that he was involved in a related arbitration in, I think, a reinsurance matter. Now, when I say related arbitration, it's related in the sense that a similar question the arbitrator was dealing with, a similar question arose in this other arbitration, this other dispute. But he forgot to disclose that. He omitted to disclose that. And the question before the court, the Supreme Court, was whether this meant that the award that was produced should be set aside, should be held to be invalid, because the argument is, had the arbitrator disclosed, made the disclosure that he should have done, it was said, well, then I would have objected. There's a prospect that the arbitrator would not have been hearing our dispute, and probably another arbitrator might come to a different conclusion. So it's unsafe because the arbitrator failed to make disclosure, and had he made a disclosure, I would have had the sense that the arbitrator may there would be apparent bias, may not have been impartial. I would have objected, and my objections might have changed everything. What the new arbitration law does is make it mandatory that an arbitrator must disclose all relevant facts and matters that may lead to a party having justifiable doubts about the impartiality of an arbitrator. So what it's doing is aligning English law of arbitration with what has actually been the practice for some time, in particular in the context of applying the International Bar Association's guidelines on conflicts of interest. That's usually regarded as the soft law gold standard on what you should disclose in connection with international commercial arbitration.
Thank you. Actually, just to pick up on the last thing you said about the International Bar Association's guidelines on conflicts of interest. Actually, I was attending the 9th Oxford Arbitration Day yesterday, and we had an interesting discussion about how far the duty of disclosure should go. And I just want to pick up on that because some people in the room tended to think that, disclose was a certain speaker used. And everyone else in the room seemed to disagree that, there has to be a limit. How are you going to remember everything? Is this not just going to incentivize vexatious litigation in terms of challenging the arbitral award, challenging the proceedings? So what do you think about that debate?
I think I'll make 3 points on the matter.
Okay.
The first point is to point out that the arbitration law, the new arbitration law, makes it mandatory to disclose what you know, relevant circumstances known to you, and what you ought to have known, what you reasonably ought to have known and ought to have disclosed. That's the first matter. The second matter is this. From my point of view, disclosure is good. I hate it because I have to go through my files and see what I have to disclose. It's very inconvenient, but it's a good idea to disclose. And the IBA guidelines on conflict of interest say, when in doubt whether something ought to be disclosed, then disclose. You should disclose. So it's all right, I think, and it is a good idea to disclose. And if you have any doubt, be safe, disclose. You don't want to be in a position, point of view, if any case of your reputation as an arbitrator, you don't want to be in a position because you failed to make a disclosure that you could easily have made, but you didn't do so. You don't want to be in a position of that sort because then a whole award might be set aside through your non-disclosure. It might be said, well, had you made a disclosure, there would be justifiable doubts as to your impartiality, and you wouldn't be sitting as an arbitrator in the matter. And after all that money has been spent making an award, only to have it set aside, not only would you feel very bad, but your reputation as an arbitrator may suffer. The third point is this. Where I worry is this. Under the IBA guidelines on conflict of interest, I think it's the latest version is 2024, you have to disclose when you have been instructed, appointed by, let us say, solicitors of one firm in more than 3 arbitrations in 3 years, in the last 3 years. Now, that's okay for me. I have enough to keep me going. But what about the young arbitrator who's just starting out, who hasn't developed a network yet? Well, he may easily find that in the course of 3 years, you're appointed by the same, let's say, solicitor's firm, because they like the way that you approach a case. And then you'll soon have to disclose at the very start of your career, and there will be an objection, and it may be difficult in those circumstances for you to say, I'm impartial, because the argument will be, well, look, if you find against the party for whom the solicitors are acting, you're going to have a pretty short career as an arbitrator. So you know how to decide the case. You'll decide in favor of the party of the solicitor's firm appointing you, right, in order to get more appointments. On the other hand, you say, well, okay, I'm going to disclose. Then the other side will object. And then where are you? You'll say, well, I'll fight on, I'll hold on. I won't recuse myself. You'll probably say, I'll recuse myself. In that case, you're in a catch-22 situation as a young arbitrator, just starting out. So I don't know how to resolve this problem, but this has bothered me from the context of the young arbitrators starting out. And perhaps there may be some way that the IBA can try to address this. But at the moment, that is the situation.
Thank you for that. Actually, I just want to pick up what you said towards the end as well. that about young arbitrators, and would you see any other barriers to being an arbitrator so young? Like when you're trying to get into it at an early stage in your career.
What is the most difficult thing about being an arbitrator or about being a judge? I think the most difficult aspect that I've found, and still am finding, is to be fair. To hear the other side, to hear both sides of the dispute, no matter what your inclinations on reading the material may be. Now, Lord Devlin, a long time ago in one of his books, I think, says that the judge comes to a case with a healthy bias towards doing justice. I think an arbitrator does the same thing. So you are a human being, you react to what you read about a case in preparing for the case. Nonetheless, you must keep an open mind and you must listen to the other side. That is very hard. Fairness, learning how to be fair. And that, I think, is the main obstacle for the young arbitrator. Picking up enough experience of life, not necessarily just of the law, but of life, of the range of peoples in this world. In this world, especially if you're into international commercial arbitration, so that you have a view of how people may react differently in similar situations. That fairness, I don't think you learn at law school. You learn only through experience. So there's no substitute for just going out and spending the time learning about the world and learning how to be fair. That, I think, is the main obstacle. Then having learned about it, to convince others that you will be fair, you will be impartial, you will hear the other side, you know what you're doing about arbitration procedure, but more than that, you will hear the substantive arguments fairly. I think that inevitably will take time, so you cannot expect to have a career as an arbitrator instantaneously. By its nature, it will take time.
Thank you. Welcome back from the short break. Okay. Thank you, Professor Reyes, for the answer you gave just now. And just to pick up a little bit on the previous answer about the different laws, the different provisions of the UK Arbitration Act 2025, you were talking a lot about I think what I'm getting is a little bit about favorability, about how different jurisdictions may adopt different laws or different provisions in the Arbitration Acts. And so can you tell us a little bit about how other jurisdictions, such as Hong Kong and Singapore, and how they compare with UK arbitration law in its current iteration?
Hong Kong and Singapore are both what are called UNCITRAL model law jurisdictions. The UNCITRAL model law is a soft law instrument put out by UNCITRAL, United Nations body, to try to show what as its name implies, a model law dealing with international commercial arbitration would look like. There are two versions of the UNCITRAL model law. There's a 1985 version and a 2006 version. The 2006 version has a few more belts and whistles, shall we say, than the 1985 version. At heart, they are very similar. Now, Hong Kong has adopted the 2006 UNCITRAL model law. Singapore, in its International Arbitration Act, follows the 1985 UNCITRAL model law, but has provisions that approximate provisions, new articles found in the 2006 UNCITRAL model law. So Singapore is a 1985 UNCITRAL model law jurisdiction, beefed up by statutory provisions to something similar, close to the 2006 UNCITRAL model law. Hong Kong is an unabashed UNCITRAL model law jurisdiction. England, on the other hand, is not generally regarded as an UNCITRAL model law jurisdiction. Why not? Let's look again at the framework of international commercial arbitration as found in the New York Convention. The New York Convention does two things, basically. The first thing is to say that if a party comes to, say, a court in a country that is that is a member of a contracting state to the New York Convention, if a party comes to the court and starts a case in that court in breach of an arbitration agreement, then because the court is the court of a country that is party to the New York Convention, the court will say, no, you cannot do that. Under the New York Convention, the court is required to say, no, we will not hear your case. You agreed to go to arbitration. You must go to arbitration. The only time when we can hear your case is if the arbitration agreement is null, void, inoperative, or incapable of taking effect. Article 2 of the New York Convention. So that's the first thing the New York Convention does. It requires contracting states, the courts of contracting states, to say no when a party brings an action in court contrary to an arbitration agreement. The second thing that the New York Convention does is it allows for the recognition and enforcement in another country of an arbitration award, a commercial arbitration award, given by an arbitral tribunal in some contracting state. It allows for recognition and enforcement except on certain limited grounds of recourse or certain limited grounds of challenging enforcement. So there are limited grounds set out in Article 5 of the New York Convention where the court of another state, the court of a contracting state to the New York Convention, can say, I refuse to recognize and enforce this convention award, or this award from a state, from another country that is party to the New York Convention. I refuse it because it falls under one of the limited grounds in the New York Convention for refusing recognition and enforcement. Now, what are those limited grounds? The limited grounds basically fall into, I suggest, two broad categories. One we might call a category of due process, international due process. So if the award was given by the tribunal, the arbitral tribunal, in breach of norms of international due process, natural justice, then the award might be set aside under Article 5(1) of the New York Convention. The other basis for refusing recognition and enforcement is found in Article 5(2) of the New York Convention. An award may be refused recognition and enforcement if it is, or if its subject matter, shall we say, is not capable, is not arbitrable under the law of the state where enforcement is sought. Under that law, some matter is not regarded as arbitrable, is regarded as not being capable of resolution through arbitration. What are such matters? Well, basically matters where there is an uneven bargaining power between the parties, consumer matters, employment matters, matters which concern more than just the parties to an arbitration agreement. So sometimes in some states, disputes over land, title to land, may be regarded as not susceptible to arbitration, or disputes regarding the validity of a registration of an intellectual property right may be regarded in a particular state as not susceptible to arbitration. So that's one ground. Or under Article 5(2) of the New York Convention, awards may be refused recognition and enforcement if they are contrary to the domestic public policy. They are contrary to the public policy of the state in which enforcement is sought. Now, public policy, as far as the New York Convention is concerned, has a very narrow focus. Enforcement of the award must be tantamount to something that is repugnant to the fundamental legal, moral, religious, cultural norms of the enforcing state. So those are the limited grounds on which you may refuse recognition and enforcement of an award. What all this suggests is that an arbitral award may really only be refused recognition and enforcement if it is contrary to international due process norms or domestic norms of arbitrability and public policy, domestic public policy. The UNCITRAL model law mirrors these grounds for refusing recognition and enforcement in an article dealing with the setting aside of an arbitral award. So if you get an arbitral award and it's against you, you may apply to the court of the seat to set aside that award. And the court may set aside that award typically under limited grounds, international due process, incompatibility with the law of arbitrability in the law of the seat, or incompatibility with the public policy of the seat of arbitration. Those under the UNCITRAL model law, if you're an UNCITRAL model law country, are the limited grounds on which you can set aside awards. Now, because the UNCITRAL model law is that, a soft law instrument, you can actually add other grounds. And Singapore, for instance, has added a ground. You can set aside an award in Singapore if it's obtained fraudulently. England goes one step further. It allows appeals on points of law against arbitral awards. So you may apply in England for leave to go to court to set aside an award on the ground that the award does not, it got the law wrong, got the law, some important point of law wrong. So if leave to appeal is granted, then you can argue before the English court that the award should be set aside because it fails to comply with some important point aspect of commercial law. And that's not typical of UNCITRAL model law jurisdictions. And that, I think, is the main difference between, say, Singapore and Hong Kong on the one hand, and England on the other. 2 footnotes. Hong Kong arbitration ordinance allows the setting aside of an arbitration award on points of law, subject to leave to appeal requirements, but it allows that if the parties opt in. That is to say, the parties in their arbitration agreement, they can agree that they will allow the award to be set aside on points of law. They can agree that. So Hong Kong, it is possible, but it is an opt-in. You have to opt in. Singapore doesn't have such an equivalent. But Singapore is currently, I think the consultation just ended, currently has implemented a consultation on whether there should be an opt-in clause, just like Hong Kong. Previously, Singapore had a consultation on whether there should be an opt-out clause. In other words, they have a provision similar to that in England, but you have to opt out. And it was decided that that would not be a good idea. Now they're having a consultation whether you should have something opt-in, and we wait to see what is the result of that. From a selfish point of view, purely selfish point of view, thinking of my role as a judge of the Singapore International Commercial Court, I've argued in a recent chapter celebrating the 10th anniversary of the Singapore International Commercial Court that it would be nice to have an opt-out, if at least an opt-in provision. Why? Because that will give Singapore, the Singapore court, my court especially, the SICC, an opportunity to develop international commercial law through arbitration cases. If parties opt in or opt out, as the case may be, out of a provision allowing for a review of the law, substantive law, as found by an arbitration tribunal, it would give the Singapore court, the SICC, the ability, the opportunity to develop international commercial law and to establish its place as a international dispute resolution hub, especially within Asia.
Thank you for the answer. Just to build up on a little bit on the differences and the different stances that have been taken. And I think one I can kind of identify is that Singapore's kind of the extreme ends, Hong Kong's kind of in the middle, and then we have England on the other end. And I'll just like to zoom in a little bit more on the differences between Singapore and England, particularly with the clash between contract and company law applying in situations of shareholder disputes. And this was an interesting discussion that I heard yesterday at the 9th Oxford Arbitration Day as well, about the different stances that were taken. So in BTY and BUA, Singapore calls them love to anonymize names, they held that company law, so the Articles of Association, overrode the provisions in the shareholders agreement regarding to the dispute resolution clause. Whereas in a different case in the UK, the court held that the main governing agreement or the agreement that they so-called SICC kind of ran through the entire process, which in this case they held was the shareholders agreement, determined the dispute resolution clause. And there's sort of like a different approach taken there between the two jurisdictions. And what do you think about that? And what do you think is more favorable in terms of?
I'm going to broaden the question a little bit.
Sure.
To some extent, sidestep the issue of whether say an agreement, take an arbitration agreement in the Articles of Association or an arbitration agreement in the shareholders and a shareholders agreement, whether one trumps the other. That may be sensitive to the facts and circumstances of each particular case, and so one must be careful in this sort of situation of generalizing. It seems to me a fact-sensitive matter. The most recent clash between what you might recall company or insolvency law and an arbitration agreement, the parties' arbitration agreement that has arisen, is in relation to which trumps which, at least within the common law world, which trumps which. Typically, in Singapore and in Hong Kong and in England, what you can do is if you believe that someone owes you money and is not paying up, you think that there's no defense to your claim, you can put out what is called a statutory demand. And that statutory demand will usually give something like 21 days. I think that's the position, certainly in Hong Kong, 21 days in which to pay up. If you don't pay up, then the failure to pay under the statutory demand is evidence of insolvency. And on the basis of that failure, you can take out a winding up petition to wind up the company on the basis of insolvency. Typically, when you put out a winding up petition, you have to establish that the company is insolvent. That is, it cannot pay its debts as and when its debts come due. That's very difficult to prove. You can shortcut that by the statutory demand process. You say, you owe me money, pay up within 21 days. Otherwise, if you don't, I'm going to take out a petition because your failure to pay the statutory demand is presumptive proof that you're insolvent. Now, what is the typical response if you're on the receiving end of the statutory demand? You will say, sorry, hold on now. We disagree that the statutory demand, that we have no arguable case against your demand. We say that your debt is rightly disputed, and what's more, you can't go to court because our contract, the contract under which you say we owe you money, is subject to an arbitration agreement. You got to go to the court first. Remember, the New York Convention provides that. So you got to go to the court first. You got to go to arbitration first before you go to court. You can't go to court. The arbitration agreement trumps that. There is at least a dispute as to whether the debt claimed is disputable. So that should be determined by an arbitral tribunal. Now, the person that put out the statutory demand, let's say the creditor, says, well, I'm going to court anyway, and takes out a petition. And the other side says, let's call it the debtor, says, no, this case has been wrongly brought before the court because there's an arbitration agreement. There should be a determination by the arbitration agreement. Competence, separability of the arbitration agreement, New York Convention, Article 2, you've got to allow the arbitral tribunal to determine the matter. Now, the question before the court is, do we go in favor of the creditor or do we go in favor of the debtor in this type of situation? Singapore and Hong Kong have decided that the debtor is right. There is a dispute as to whether there's a dispute, and the matter should be stayed to arbitration. The court should not determine the matter. In the recent case of Siam, the Privy Council has held that the creditor is right, that the public mechanism of corporate insolvency trumps the private mechanism of an arbitration agreement. The arbitration agreement is simply between two parties. Only two parties are privy to the arbitration agreement. Insolvency is something that concerns the public at large because it concerns the whole pool of creditors, not just the parties to an arbitration agreement. So whatever the arbitration agreement says, the debtor must, before the court, establish that there is an arguable dispute. Otherwise, the statutory demand is effective and a winding up petition should follow. The arbitration agreement should not be used as a means to delay the inevitable if there really is no argument, no defense. Now, so you have these two different or three different jurisdictions coming to different conclusions. Now, there's been a recent decision of the Malaysian Federal Court where they have agreed with the English or Privy Council decision in Siam. For good measure, by the way, the Siam Privy Council said, by the way, although this is a Privy Council case, we are now declaring that this is the law for England as well. We made a mistake. There's a previous English case that followed Hong Kong and Singapore's approach. That was in error. This is now the approach in England. So you have that different approach. Which trumps which? The so-called public process of insolvency or the private two-party agreement as embedded in, as exemplified by the arbitration clause. Now, my own personal view, for what it's worth, is the Hong Kong-Singapore approach is the correct one. Why? Recall, under the New York Convention, it is an international obligation, international law obligation, to stay court proceedings wrongly brought in breach of an arbitration agreement, unless the arbitration agreement is null, void, inoperative, or incapable of taking effect. That's an international obligation. Now let's look at the arbitration agreement in the typical statutory demand case. I'm here positing that it's an international commercial contract. Is the arbitration agreement null? Certainly not. Is it void? Certainly not. Is it inoperative? Certainly not. Is it incapable of taking effect? Well, it is capable of taking effect. I don't think you can say, well, because it's a corporate public insolvency process, it's incapable of taking effect. So in order to be in line with your international law obligation, you need to say arbitration agreement. That takes priority. Well, in Siam, it's said, no, not quite right. Not quite right. The it's a public process. I don't think that's correct. In insolvency law, certainly in Hong Kong, Singapore, and in England, if a creditor steps outside, the court says to the creditor, you cannot proceed with your petition. There are other creditors around, and other creditors can say, well, I'll take over. I'll be substituted. I apply to be substituted for the initial creditor. That's called substitution. And that is possible procedurally in insolvency cases. So if the person who is bound by an arbitration agreement is unable to continue, then another creditor can say, well, there's no arbitration agreement with me. I want to be substituted. So how is this public element affected in any way when you have substitution? On the other hand, if no creditor wants to be substituted, then how does it become public? It's purely between the two parties. So it seems to me that that has not really been grappled with in SIAM. Now, in a recent conference on this matter, the one participant said, well, there really is no dispute at all. I find that hard to believe, because it seems to me, at the very least, there's a dispute about whether there is a dispute.
Thank you for the very enriching academic discussion that we just had. Maybe to just wrap it up for today, I wanted to ask something that's slightly away from academics. In terms of where do you see the future of private international law going, and what should us undergraduates be doing to grow more in this field? As people who are interested in private international law, international dispute resolution, what should we be doing?
Private international law traditionally embraces three topics. The first topic is jurisdiction. Does a court have jurisdiction to hear a particular dispute? The second topic is choice of law. If the court has jurisdiction, what is the governing law, or what are the laws that govern particular aspects of the dispute? Choice of law. The third matter is recognition and enforcement. Assume that the process puts out a judgment in an international commercial dispute. Will the court recognize and enforce that judgment? Will a foreign court recognize and enforce that judgment? Those are the three traditional subjects of private international law. The Hague Conference on Private International Law, the Hague Conference based in The Hague, adds a fourth topic to that, and that is the harmonization of private international law principles across borders. So there are the four topics. It seems to me, however, that that is not enough. And the future of private international law requires that we deal with questions that affect us, everyone, in cross-border situations. And because our world is getting smaller, however anti-globalist it may be, or maybe becoming, there will always be cross-border questions. Let me give some examples of cross-border questions that may not be susceptible to traditional private international law analysis, and which we must develop as private international lawyers tools to deal with. Climate law, climate change litigation, sanctions and counter-sanctions, the enforcement of human rights diligence amongst multinationals, the questions about promoting human rights to a healthy environment across borders. All these are questions which, like it or not, will affect all of us. Now, how does private international law deal with this? If you apply jurisdiction, a court might say, well, I don't have jurisdiction because the pollution took place in another country, so I reject jurisdiction. And under the law of that other country, it was perfectly legal. So I reject, there is a choice of law question. A recognition and enforcement, well, we never get to the recognition and enforcement stage. If you simply apply a private international law analysis to many of the problems besetting the world today, I'm not sure you're going to be doing justice. So what it requires us, your association, to do is to develop the tools, the means, the analysis, the approach to dealing with the problems of concern today. And that may mean riding between domestic law and private international law principles and international law, public international law. So we must not draw up silos. We have to try to integrate the three.
Yeah, thank you. And that wraps up our episode for today. So thank you so much, Professor Reyes, for your time. And I look forward to having you on the podcast again in the future.
Thank you very much.
Thank you.